Members of the committee, for the record, Mike Kehoe representing Missouri's 6th Senatorial District. Mr. Chairman, I might add that you are running a fine committee, and it's like a well-oiled machine. I'm glad to hear you're cooking with gas. I am here to present to you Senate Bill 356. Many of you who were on the committee remember this bill from last year. As a matter of fact, this bill made it out of committee and out of the Senate, I think by 27-5 last year. It's what I call my kind of common sense liability, limited liability for manufacturers. And it has to deal with material alterations. So if a company were to manufacture a product after it is sold to the end user, if that end user were to alter that product in a way that was not designed or approved by the manufacturer would not be held liable. We've got a couple of folks here to testify in favor of this, but I wanted to say before they did, because they're both Missouri manufacturers, can explain this to you very well. Just in a common sense terms, where I have seen this particular bill be useful. First of all, it doesn't limit anybody's day in court. What it basically says is that if I buy a post hole digger, and this is a real live example, and it is built with a shear pin that goes into the auger that is designed to break at a certain, RPMs, or when it gets stuck on a rock or something, it's designed to shear to keep the auger, to keep it from turning. And I'm out in the middle of the field, and this happens to me, and I'm trying to get this fence post hole dug, and I run and grab a piece of rebar or a screwdriver out of the tractor toolbox. Not saying I would have ever done this, Mr. Chairman. And I shove it in that post hole to keep going. The man who manufactured, the company manufactured that auger should not be responsible for me materially altering the product. And so that's what Senate Bill 356 does. It provides some common sense protections to our manufacturers for their products when they do become materially altered after it leaves their assembly plant. Senator, now Judge Goodman, was very helpful in helping me craft some pieces of this last year to fine-tune it a little bit, and I believe we had it in a spot where it seemed like it was acceptable to the Senate. With that, Mr. Chairman, I'd be happy to take any questions.
Ladies and gentlemen, I'm pleased to have the opportunity to come before you and share some time with you. I am Joey Danuser, the third generation president of Danuser Machine Company in Fulton, Missouri. Needs a lot of help.
Thank you.
Okay. In 2010, we celebrated our 100th year in business as a family-owned business. The fourth generation is actively involved in running the company on a daily basis today. We currently have 70 employees with an average employment of 16 years. The general economy and current challenges have reduced our workforce. One of the greatest challenges is product liability. Danuser Machine Company made the first mechanical mass-produced post-hole digger that I'm aware of. Remember, we're talking about a time when men dug post-hole diggers or post holes by hand. In 1944, it suddenly became possible for one man to drill hundreds of holes in a day with a tractor-powered implement. At that time, there were no safety standards for post-hole diggers. Today, we are guarding in 3 different locations and safety signs, decals all over the machines. Although our first post-hole diggers were not guarded or covered in decals, safety has always been foremost in Danuser products. Post-hole diggers went from a hand-powered tool to a tractor-powered implement. Danuser diggers were designed to dig holes sitting down with one operator sitting in the tractor seat. I ask you to get involved with a group of Missourians who are tired of risking Missouri jobs and quality Missouri-made products. Please be a part of this change that other states already have to protect their workers. If after the initial sale of the product, someone alters or modifies it, changing the product purpose, use, function, design, and or intended use stated by the manufacturer, then alteration or modification should be an absolute offense. Thank you for your time and attention.
Mr. Chairman, members of the committee, my name is Alex Curchin. I'm here to testify on behalf of the Missouri Chamber of Commerce. I want to thank Senator Kehoe for bringing this bill forth. We believe it offers a balanced approach in that products here in Missouri are sold into the stream of commerce, and sometimes the materially altered in order to extend their life or to correct or allow them to perform a different task than they're otherwise designed. Senate Bill 356 is a recognition that those products sometimes are materially altered, and we need to protect the businesses from those alterations by consumers of the goods where it is performing a task that was never meant to be performed as designed. Senate Bill 356 also represents a legislative initiative that promotes a balanced approach. Plaintiffs still have the cause of action if they can prove that the product was sold into the stream of commerce, sold in a defective condition, the defective product was used in a manner reasonably anticipated, and the consumer was damaged as a direct result of that. So it protects Missouri businesses, at the same time helps protect plaintiffs and their valid cause of action. Be happy to answer any